I'm Ed Walters, and today I have the great pleasure of talking to Tom Bruce and Peter Martin, the founders of Cornell's Legal Information Institute. So today we're going to talk about the founding of Cornell's Legal Information Institute, how a former dean of Cornell's law school and someone who's really working in the kind of production, IT, video production for the law school, came to found a Legal Information Institute that became an inspiration for the whole world. In hindsight, it seems inevitable. It had to happen exactly the way it did. But we're going to talk about how it was anything but inevitable. It wasn't certainly going to happen. Even the web itself might not have happened the way it did if it weren't for Peter and Tom. So I think for people in the 2019, 2020 era, if you talk about the internet and the World Wide Web, they're sort of the same thing to people. But that's not really how things started. And in the early days, especially academic computing centers were working on this internet that would connect remote computers to each other, but there wasn't even a World Wide Web. And this is the world in which the two of you started working with law online. Tell me about the early development of the World Wide Web and the role that the two of you and Cornell's Legal Information Institute played in the development of the early World Wide Web.
Well, I suppose it's most important to say that we didn't start out with World Wide Web. We started out with a system that I think is now largely forgotten, called Gopher. It had been developed as a platform to do campus-wide information systems, actually originally at the University of Minnesota, and it had sort of spread among network techies as a thing to try. And it did a lot of things that you would want to do. It was great if you wanted to publish course catalogs or events calendars and stuff like that. And it was easy in the sense that you didn't have to do linking of specific words to other things in the way that you do in HTML, for which of course there were no editing support tools at that point or anything of that sort. But it was also quite limited in the precision with which you could make references, right? So basically it was menu driven and menus pointed to things, and they could point at things that were somewhere else on the internet. And I think our first venture into that was actually taking Title 17 and putting it into Gopher. I think that was
that could be, although were we also pointing at the FTP side at Case Western? I'm not sure.
I think we may have been, yeah. I think we may have tried to provide an index to Supreme Court cases.
Which is where Supreme Court decisions were going at that point in their original word processing format.
Right.
Just stuck in a retrieval site at Case Western.
So in Gopher, you could point to the whole document and pull the whole document. You
Right.
weren't using hypertext links to individual words or...
In fact, you could, in this instance, have to point at each file, of which one held a syllabus, one held a majority opinion, one held a dissent, and
Right.
so forth.
Yeah.
Right. So what year is this now?
This would have been 91, 92.
Okay. Was there a Legal Information Institute yet, or was this a project the two of you were working on?
We got the dean's approval. We got funding in spring of '92 using the label Legal Information Institute. I had discovered that while you couldn't be a center at Cornell without getting major approvals, anybody could wrap themselves in the label Institute. And so that's what we did. And then we got the dean's approval later that year to use that as our brand. And so we were an institute in '92. That was 27 years
And
ago.
honestly, I mean, we really couldn't think of anything better to call it. I mean, the institute part of it was magical. It was like, what are we going to call this thing?
Well, the other radical thing we did in '92 was declare ourselves co-directors,
Yeah.
which had immense value that we did not totally foresee, but it gave us a chameleon quality. To some, it was Tom's institute, and to others, it was Peter's institute, and it depended on the constituency who saw it which way.
It was kind of who we were talking to. I mean, we would be at AALS law teacher meetings, you know, and I would be seen as some sort of strange Igor-like creature trailing along behind Peter's Frankenstein, and you know, we would go to tech conferences, and he would be this guy that I was somehow carrying on my back. I mean,
Right.
it was insane, really. I was completely unprepared. by my background or anything else, to the extent to which collaboration does not take place in academia. It really doesn't, at least not outside the sciences. And that was a head shift. It was a head shift for us, and it was certainly a head shift for the institution.
It's interesting though, because at a time where law schools didn't collaborate, really for the first time with the internet and later the World Wide Web, the architecture of collaboration was there in a way that it previously wasn't, right? You had the architecture for law schools to host different parts of collections and connect to each other. And in a way that you were operating in an environment that didn't collaborate much, but you helped to create an environment that allowed it in a fundamentally new way.
Well, you'd think so. I mean, I'm honestly still agnostic about the extent to which anyone has taken that up outside, well, obviously information consumption in one form or another,
Right.
Blogging, really.
Yes.
Well, there was a memorable meeting of law schools, I can't remember the total population there, when the question was, what shall we do about the U.S. Courts of Appeals? What was born of that was an idea that different law schools would take on the task of mounting the decisions of their regional U.S. Court of
Right.
Appeal. And where's that today? You know, I mean, so a lot of the collaboration was there for the moment, but did not sustain.
So most people don't know this, but for a time in the sort of late 90s, I suppose, you would have like, I can't remember, it was like Purdue had one of the collections, and Vanderbilt had a collection of like Sixth Circuit opinions, and you'd have different law schools who were collecting judicial opinions from the circuit courts of appeal.
And the Herculean task that Tom took on was, he said, well, you all mount it, and then we'll create we'll index them so that you can search across all of the circuits on a particular topic.
Yeah, that was a foolish venture. I mean, you know,
Which spoke of the degree of collaboration that was really possible out there, because it just didn't.
I mean, the problem that all of that had, of course, and we had it too, was that everyone was doing this in a way that was seen by their home institutions as being very much on the margins
Right.
of what law schools did. I said to one incoming dean here a while after that, I think it was around 99 or 2000 when Lee Teitelbaum came in, I said, I feel sometimes like I'm going to people and saying, I'm the greatest ocarina player in any American law school, because they start looking at you and say, well, I'm sure that's an accomplishment, but who needs an ocarina player?
No, we could talk about various fortuitous elements. One was that there was a new dean when we started doing this duo, and we brought in substantial outside funding. I mean, we had NCARE support, National Center for Automated Information Retrieval, 4 successive one-year grants, and then a capital grant, and then we got Atlantic Philanthropies in there. So we were bringing in outside money that he could use to deflect. He was pleased with what we were doing, but he could use to deflect internal criticism of the enterprise.
So during this time, this is the early days of Cornell's Legal Information Institute. You have the first grant funding for it. You're setting up as an institute in the law school, not a center or something that is in the more traditional mold for law schools. And there is this internet that connects mostly university computers for the most part.
And on which, if you call yourself an institute, then people imagine some degree of scale and longevity that we were just pretending at.
Well, you were at the beginning of it.
Well, no, I mean, it's funny because in recent years it's been more difficult to make the transition into having a real communications director and otherwise behaving like we care in some way what the world thinks about us, because at the beginning we were really, we were blowfish. There's just no question about it. We were this huge presence on the internet with 2 guys sitting in some office at Cornell.
During this time, where were you hosting the materials? Did you have like a big server in a basement?
I sense you know this story already, but in fact our first server came to us as a result of someone in Cornell's central computing apparatus having had one too many gin and tonics one Friday afternoon. I said, Steve, can I borrow a machine? He said, sure. And that proceeded to be our machine for, I think, the first year or two.
The Sun Spark Station.
Yeah. And it was sitting in a room. We eventually got something slightly more dignified. But as we added systems, we added personnel, of course, as well. And nowadays, I don't think we have, there are those who could correct me, but I don't think we have any physical hardware running in this building at all, or for that matter, anywhere. It's all out in the cloud.
Past the like sort of foundational phase, at some point in the, I'm going to say like 95, 96, 97 phase, you had to have realized that things were really taking off. When did you realize that you had really made it? That this institute was going to be around for a while?
I don't know that we've made it yet. I mean, I always figure that, you know, I'm good for another 2 years at Cornell. It's hard to point at that moment, and I'm sort of not joking about it because I'm not sure we ever had it.
I don't think we said we're here. I mean, I alluded to the change of deans. That was very definitely a point at which we had to face the hard question of, do we still belong in this institution? I mean, we had to persuade another dean that this foreign element embedded in Myron Taylor Hall really should stay. So that I think there was continuing search for where to do what and how to do what we wanted to do, but and clear recognition that we had done something that we wanted to sustain. But the question was how to do it.
Yeah, I mean, it really all fell into the kind of dominant situation in law schools, which was, first of all, that technology went very quickly from being seen as something novel, unfamiliar, and scary to being something that was infrastructure at the level of plumbing and could therefore be taken care of by those people,
Right.
whoever those people are. We were doing something that was certainly not a mainstream activity for an American law school, and still is not, somewhat to our surprise, I think. And so there was a lot, and in general, technology was being struggled over, even as an infrastructural service, as between the law libraries and the people who had been hired as professional technologists, to the extent that they had been. And that was by no means universal among law schools. So we were just sort of right in the middle of a swirl of administrative confusion over whether we should be here at all. If we were here, who should be doing it? Who should own it? Should it be part of the library, et cetera, et cetera, et cetera. And to some extent, I don't think that fully subsided until maybe 5 years ago, if then.
One critical decision that the two of us had made early on was that if we could, we wanted to stay embedded in the university and in the law school, in that order of priority, and that we didn't want to do what some others had done, which is to hop out into the private sector, either as an NGO or as a for-profit.
You must have had those options many times over the years.
We certainly contemplated it.
Yeah, we certainly did.
So an institute like this is pioneering. There wasn't really anything like it at Cornell or indeed at any law school in the world. And yet the mission really wasn't that distended, that different from what law schools had always done, and maybe connected to that land-grant mission as well.
Well, we surely didn't think it was all that different.
Now, you say anywhere else in the world, and let's drop a couple of footnotes and say that fairly early on, from elsewhere in the world, surfaced people saying, do you mind if we call ourselves a Legal Information Institute too?
When was the first one who did that?
It was the Canadians, and it was in late 92 or 93. They had started from a platform within the University of Montreal to publish Canadian Supreme Court decisions, and basically wanted to license the name. A year after that, the Australians showed up wanting to do the same thing.
So Canley Ostley.
Yeah,
They really took the mantle of the Legal Information Institute, the name that you guys had sort of created from scratch, then became the brand of open access publishing for entire nations.
oh yeah.
Yeah, it was January of '96 that I helped launch the Zambia Legal Information Institute, which was the first sub-Saharan African instantiation of the notion.
Today, of course, they're all around the world.
There are now, I think, 23 in the namesake category, and a bunch beyond that that are just kind of aligned with the mission.
You get them together every year now, right?
We don't.
They get themselves together, and we happily sit and nod and smile and look old.
Well, the two of you probably can't say it about yourselves, but I can say this, having been to a number of the kind of global meetings of the Legal Information Institutes. You guys are a beacon to the world. Everyone sort of looks to Cornell's Legal Information Institute as the success story that they want to build their open access publishing on top of. They are standing on your shoulders in many ways, really increasingly around the world. People starting Legal Information Institutes because they want to build on the kind of success that the two of you had.
But the brilliant thing, Ed, is that some of them have done it quite differently, with really very different missions, and certainly under very different local conditions
Yeah.
than obtained here.
In business models vary hugely, of course. People find different sources of funding and whatnot, but so does intention. I mean, one of the things that Peter said to me very early on was, American law is really an export product. But as it has turned out, there are lots of people out there who see their law as an export product. The most obvious example, for the most obvious reason, is the one that now exists on the island of Jersey. They would like everyone to know what their tax laws are.
Right.
Because they are a major tax shelter for the UK. But that was a key point that occurred to us very early on. That's one of a long list of ways in which open access to law functions in ways that do not exclusively serve lawyers, or indeed anything that you think of lawyers as doing very much, right? I mean, and it's certainly an advertisement for economic opportunity. Rwanda has done a remarkable job of putting stuff up there that is designed to tell investors that A, they have rules,
Right.
and B, they have the capacity to enforce them, which is actually not a small thing.
No, the rule of law, what better way to advertise that your nation promotes and advances the rule of law than to publish your law online so that everyone can see it in a transparent and free way.
Yeah, I mean, I've always found it very useful to think about what we do through the lens of somebody who doesn't actually have a dispute.
So give us an example of that.
Well, it's basically anyone in business doing risk management that involves some aspect of law, right? I mean,
So you've talked to me about, for example, a dry cleaner.
Yeah, well, I mean, yeah, this is my favorite pet statistic, right? I mean, there are, I think, 80,000 dry cleaning businesses in the country. Most of them are family owned. I mean, they're small. There are 100 and some odd provisions of the Code of Federal Regulation that relate to one dry cleaning chemical. These guys need to know what to do with their toxics. They need to know how they're being regulated. They need to know what they're supposed to do. And really, my version of our highfalutin mission statement is basically that we're just trying to make it possible for people to find out what they should do. What am I supposed to do? It's really a pretty good question, especially in a highly regulated business environment.
After Cornell's Legal Information Institute, you have Justia, publishing law for free online. Google, publishing law for free online. It became something that one does. Legal information institutes around the world.
Let me also insert, one of the things that we hope to do and have been really quite successful doing is shaming the public bodies themselves
Yes.
into releasing their law in digital format. Take the New York Court of Appeals, or the U.S. Supreme Court. New York Court of Appeals in the early 90s launched a dial-up bulletin board. You had to pay, I don't know, 30, 40, $50 to dial up and get decisions. We discovered in a meeting with some New York bar people here that one of them had been doing that, archiving them, attaching his own citation system to them. And he said, hey, you want my archive? So suddenly we found ourselves in the business of putting up the decisions of the New York Court of Appeals.
Credit where due. What's his name?
Jack Lippert.
Yeah.
Jack Lippert. And so we used to then get the decisions from Lippert, who maintained his subscription, because
You never know.
they were not furnishing public access.
Right.
And he was prepared to be our go-between, so he kept funneling them to us and we put them up. And finally, the New York Court of Appeals put up its own website.
I remember Lippert's first approach to us. It was like he was trying to sell us postcards and announcing. This is great.
Well, because at the time,
Yeah,
right,
So-
I think he's way outside the terms of service on the bulletin.
public access to law was not even a thing
Right,
people were thinking about.
Right.
Right?
So
You would ask to publish.
we every year for a period of time we published an honor roll of the states, honor roll of those states which were putting their statutes up in some reasonable form, honor roll of the states that were putting up their appellate decisions in some reasonable public access form.
And it should be said.
And it was a growing honor roll to the point that we, in the end,
You could also say that it was a list that was read mostly for its omissions.
Yes. But I think you have to say that we're at a point in time now where everyone does. I mean, there are some weird corner exceptions, but they're really long tail exceptions to this point. You have created a norm. What are you proudest of?
and well, I would also mention the times when you saw the light bulb going off. I mean, we were able to present people with possibilities that they didn't necessarily see. And so I've got some of those moments, and I'm sure Tom does too. You know.
Oh yeah, I mean, of course. You know, you ask what I'm proudest of, and I'm going to give you a very, very parochial sort of answer to that. It is not the norm for programs in law schools to survive their founders. Far from it. I mean, I can think of one program other than us that has. There are probably more, but the one that comes to mind is the Harvard Program on Negotiation. And I don't think there are many beyond that. You may know of them. I can think of a lot that haven't. But the fact that despite, frankly, considerable institutional incomprehension, not to say resistance, we've been able to sort of institutionalize the thing as successfully as we have, with help from you, with help from Tim Stanley, a bunch of other people, has been really, really important to me. I mean, this is work that it needs to be done. It's obviously not always going to be done by me or by Peter. It's nice that it seems to have found a relatively stable home at Cornell for at least a while. You know, I'm very pleased with the way that we've been able to sort of institutionalize it and guarantee that there's some succession there. We've had a lot of help from the current dean with that. You know, that I think is the best thing that we've accomplished. Simply, you know, you get to a certain point, and Ed, I think you of all people would recognize this. You get to a certain point where you're playing for free games. And the more free games there are, great.
Right.
You know.
But you know, here we are 27 years later, and the LII is one of the ways that most people know Cornell Law School, most people in the world. It has a brand that has become truly global and a beacon for the world. Again, you guys can't say it about yourselves, but as someone who works in the kind of legal publishing world and legal software, the entire universe of people who do this for a living look to Cornell's Legal Information Institute as the cornerstone. You guys are the architects of everything that followed, an inspiration to countless, hundreds, thousands of people who have started legal information products, and their very orientation about this is always public first, in part because Cornell's Legal Information Institute was public first. There's also a diaspora of people who have worked here.
Yeah,
True. Yeah.
True.
How many law students have worked at Cornell's Legal Information Institute over 27 years?
Lord Craig could probably tell you, but it's, counting the bowling
Hundreds?
kids, it's well into the 500 to 600 range.
Right. People who take that expertise into jobs in law firms and academia, public defenders and judges.
There have been other kinds of affiliates. I mean, we've worked with a good number of law librarians here and there, and some people out of firms and whatnot. So, yeah, good number.
Do you guys have any closing thoughts?
No.
No.
Brevity is the soul of wit.
That's right. That's a pretty good closing thought.
Yeah.
Yeah.
Well, it sort of comes from all those stories, right? To choose to pick your battles and stay in federal law instead of expanding to states, to really work the codes and to do something, that is exquisite but constrained. To do one thing really, really well and then another thing really, really well instead of everything in a mediocre way.
Yeah, I think that, what constantly astonishes me about the people who work here is just the depth of expertise they have in the really, really important minutiae of legal publishing. We always start with a new programmer explaining, no, actually, you don't correct spelling errors because that's the law as it's published. And they sort of go from there to really understanding depths of mechanics of citation and stuff like that in ways that I think very few people in the country do. I mean, there's an enormous amount of expertise here that's been developed over years, and that's only happened because we have stayed fairly narrow in focus,
Right.
and because frankly, I mean, Peter will hit me over the head with the nearest blunt object, but I have a fear of and a sort of disdain for case law. Everybody's doing case law,
Right.
I was much more fascinated with regulations, and I pretend that I don't see its utility. Of course I do. But for the audience that we have been interested in, or for a big part of what is a global audience for this stuff, it is an interpretive layer on top of other stuff, not where you start.
Well, I have the great joy of being the proxy for millions of people around the world for whom you have democratized the law, whose only experience with the law has been through Cornell's Legal Information Institute, for lawyers who overpaid for access for many years, for law librarians who get to work with partners who fully understand the structure of citations, who understand in a deep way the meaning of things, for countless business owners who understood how to run their businesses better because you made the law accessible to them, to an entire generation, 30 years of entrepreneurs who draw inspiration from the work that you've done, and from the diaspora of law students who have had the privilege of working at Cornell's Legal Information Institute. You're a beacon for the world. You're an inspiration for all of us. And on behalf of all of those people, thank you.
Thank you, Ed.
Thanks, Ed.